Good afternoon, Paula, and thanks for spending some time with us today.
Thanks for inviting me.
Can we start by telling me a little bit about yourself and how you got started in business?
Oh, okay. Well, I was a physics major at UCLA, and a professor said to me, "Oh, you don't want to get a PhD, believe me, you're not going to like sitting in a lab." So he said, "Well, you ought to go to law school." So off I went to law school. And then I was at law school, and a professor said to me, "Oh, you've got a physics degree, why don't you try to apply for a job in a patent firm?" I thought, oh, that sounds like a good idea. So I did that, and I got a job there, and I've never looked back. I've always been in IP since then.
So today you're going to spend a little bit of time telling us, imparting some of the knowledge in your specific area. So can you start by telling us, what is the difference between tangible and intangible assets?
Well, in a company, you're going to have a set of books, and your books are going to list your assets. And some of your assets will be maybe the cars that you have, or your building, or machinery. Those are all tangible assets. The other column that you are allowed to use in your books is the intangible asset column, which is actually recognized internationally by accounting gurus. I don't know, there's an organization that recognizes accounting procedure internationally. And intangible assets would include goodwill, so the goodwill in your business, you've got a name for yourself, you've got customers coming in and out, you can actually put a value on that. You've got key persons who work for your business, whom without them you might not have such a great business, and you might put a cash value on those persons. Those persons you might have insured under key person insurance, and that's how you could evaluate the value of those persons working for you. There's contracts that you've got with your suppliers and your employment contracts, and there's a whole list of things that you can include under intangible assets. Another category of intangible assets is intellectual property. And so that is under the umbrella of intangible assets. And so if you have intellectual property, say your trademarks, copyrights that you own, patents that you have, copyright or designs that you have. There was one with trade secrets. There's a whole list of intellectual property that fall also under intangible assets that could be part of your valuation in your company.
So when a business is starting out, we often tell them to start looking for the intellectual property aspects, the IP in their business. How would somebody go about actually working out where their IP sits?
Well, first they'd have to figure out what the difference between the different types of intellectual property are. People know about patents, or patents as Australia doesn't call them. And they know about trademarks, and they know about copyrights, and they may know about designs, but each one of those types of intellectual property has a discrete, different set of rights involved with it. There's a discrete set of legal obligations that you have in order to procure those rights. And so you need to learn about what you need to do to obtain a patent, to obtain a registered trademark, to obtain a copyright protection or design protection individually. So you would look at each type individually, and that would give you some guidance there to figure out what you own.
Do you think if you're just starting out in business, and cash flow is a bit of an issue, at what point do you start looking at actually protecting your intellectual property?
Immediately. The reason being is, well, it depends on what type of business you have, obviously. If you have a tech business, most likely you're going to be looking for funding. And investors are quite keen on intellectual property. Patents, people are afraid of patents for a few reasons. Number one, the cost. Well, I can talk about that in a minute. They say, I've heard from people, oh, well, you can't enforce a patent because it costs too much. Well, that is probably the last reason why you want to get a patent. The enforcement is really not what you get a patent for. That is the last reason. The reason why you get a patent is because it promotes a perception of innovation. And if you have a portfolio of patents, and in fact, it doesn't really matter what the portfolio of patents has in it, but if you have a portfolio of patents, investors, including banks, and in fact, all of your community, your business community is going to look at you, oh my goodness, you're so innovative, you've got all these patents. Well, we can talk about really what a patent is at a different time, but that's more the reason why you want them. There's another reason, is because if you're in a competitive market, like in the old days, smartphones was a competitive market, so as you know, there's hundreds of thousands of patents on smartphones. Your smartphone has at least 250,000 patented technologies associated with it. Yes, that's a lot. I know that surprises everybody. I worked for Motorola for 7.5 years. I wrote a lot of patent applications for them. I know what they do in there, and there's a lot of patented technology in smartphones, which is why there are so many patent litigation matters involving smartphones, which involve probably 30 or 40 different companies all suing each other. So one of the reasons why you have a portfolio is to protect yourself from litigation. Because if you are being sued by someone, you can or if they're looking at suing you, you can potentially cross-license with them. And you can avoid a litigation matter because you just call a truce. Look, I'll license mine to you and you license yours to me and we're done. So there's another reason, a third or fourth reason, I've lost count, is that you can sell them. BlackBerry, for example, as everybody knows, is losing market share. In the last year, they have filed about 1,000 patent applications. And the reason why they're doing that is so that when they finally do end up on the bidding block, they will have a higher value. They expect their patent portfolio to fetch about $1 billion to $3 billion. So, you know, their efforts right now, instead of worrying about their market share, is to shore up their IP. So you can sell your patents. There's a lot of places you can sell them to as well. There's, I hate to bring up the patent troll issue, but patent trolls buy patents. So that you can sell them, you can trade them, they are a perception of innovation, and then finally, if worse comes to worse, maybe you might enforce them.
Okay. So can we talk a bit about software development and protecting IP around software? Because a lot of the startups have a software element to their business. What can they do to protect their investment in building a business that has software as a major component?
One thing I want to talk about first is copyright issues with software. Got a little bit of rain. Copyright issues with software. I've had a call or two from some software development companies who have contracted out software development, but failed to get an assignment back to them on the software that was developed for them, and then these developers ran off with the software. Copyrights, they attach to the creator of the creative work, which software is. So if I doodle something, I own that doodle. If I write code, I own that code. And if the company who is contracting out that software development doesn't get from the developer assignment back to the company, the developer owns the code. And I've seen that happen a few times. So the first things first, when the software company is contracting out, they need to make sure that they get assignment back of the copyrights. Now, there's been a lot of discussion about software patents over many, many years, I was writing software patent applications before software was patentable in the United States in the early 90s. And then laws changed and laws changed and laws changed to the point where just recently some patentees were getting patents on literally algorithms, which don't have any physical anything attached to them. And the United States Supreme Court said in CLS versus Alice, it just came down this year, that no, we don't want, this is not patentable subject matter. An algorithm is not a patentable subject matter. So there were a lot of complaints about this, but in a big way, it wiped off an enormous amount of value off the books of patent holders because, frankly, I think their patent attorneys got sloppy in writing patent applications on algorithms. So since the patent office was allowing them, they kept doing it, and it just kept happening, and the patent office needed to get pulled back and say, no, this is unpatentable subject matter. So, but in my practice, I've always written my patent application so that there is something tangible on one side and something tangible as output. And if there's a tangible thing on the input and a tangible thing on the output, then there can be some algorithm in between. And that's what we do when we write a software patent application. We make sure we frame it that way. And it's all a matter of wordsmithing.
So when do you think, if somebody has developed a software product, at what point should they be speaking to a patent attorney to actually make sure that they protect it?
Okay, the most important thing that anybody, if they remember anything from this tape that they're listening to, is that they remember that they will lose their patent rights if they disclose their invention. So they need to talk to their patent attorney before they do make any public disclosure without a non-disclosure agreement. And that means that they can't show it to anybody, they can't go and try to sell it off on Kickstarter or one of the crowdfunding organizations. They must file a patent application before public disclosure in order to maintain their patent rights. Now, the one thing that's very tricky is in the United States and in Australia, even if you offer for sale your technology but you cannot tell what's patentable about it, like the invention is embodied in some bigger thing, and somebody looking at it wouldn't know what they were looking at. They would have no idea about the technology on the inside, but if you attempt to sell it, not even whether you sell it or not, just make the attempt to sell it, offer for sale that product, embodying the invention, you lose your patent rights. So the most important thing that any inventor or any company that has any type of patentable inventions can do is to first not disclose their invention to anybody in public, or try to sell it before they get at least a provisional patent application on file about it. So they need to talk to their patent attorney before they disclose their invention publicly.
So how would somebody actually go about finding a patent attorney? So, it's great that we're talking to you, but do they go to a specific law firm, or do they go, is a patent attorney somebody that's associated with a normal law firm, or is it somebody who's really specializing that they can find individually?
That's a really good question. They can ask around their business friends that might have used a patent attorney. One of the problems with the patent business in Australia have come from the United States, where it's actually quite different. In the United States, lawyers are patent attorneys. In Australia, patent attorneys are not lawyers. So there has kind of developed a very specific niche market for Australian patent work. Most of the patent work that comes to these patent attorneys in Australia is from overseas. 90% of the patent applications that are filed at IP Australia are filed for foreign entities. Only 10% are filed for Australians. This means that the patent attorneys can pick and choose their clients. And oftentimes, they pick and choose the ones with the most money. So, the way to get around that problem is for and I never, ever, ever tell anybody to self-file their own patent application. That is asking for trouble, enormous amounts of trouble. This is a highly specialized field of law, very regulated, lots of things that you have to do to become registered, so do not do that. But what I recommend people do is learn as much as they can about preparing their own patent specification. And that includes learning how to write claims, understanding what a patentable invention is, how to claim a patentable invention, how to write the description to support the claims, and then once they've got this kind of under their belt of being able to prepare the patent application on their own, then they see a patent attorney, and that patent attorney helped them by fixing it up for them so that it's in condition for filing at IP Australia or the USPTO or wherever it goes to be filed. But as much information as a business individual can obtain about what is a patent, how do you claim an invention, what is a patentable invention, what are we talking about when we're talking about a patent, what do we really mean, what are the nuts and bolts of this thing, and then learn how to write them themselves. They can find a patent attorney, there are patent attorneys, including myself, who will put those patent applications in condition for filing and not expect $10,000 to do it. We still bill our hourly rate, but the better the client gets at putting these things together, the more value that the client gets out of the patent attorney. Like I said, they have to call around to see if there's a patent attorney that will do something like that for them. That's not so easy to find. I do that, but there are a few others out there that will do that, and I think that the patent business in Australia is starting to get a little bit more competitive, where there might be opportunities to find patent attorneys that will do that. But the last thing I think anybody who is starting a business on a shoestring wants to do is just walk in with no knowledge, no understanding of this business, no understanding of what it is they're trying to do for patents, and walk into a patent firm without 10 grand in their pocket, because they will just turn you away. So
can we get an idea then for all of those startups who I'm sure are watching this and have realized that they need to do something about it? If they had to go and see somebody and go through that process you've just described, what should they set aside to be able to pay for the process that they go through?
If they write it themselves?
If they do the groundwork themselves.
If they do the groundwork themselves, it's probably $3,000 plus the filing, which is usually about $700 because a firm handles the filing, and there's a lot of infrastructure that a patent firm has behind it. I mean, there's a massive amount of bureaucracy, and that's one of the reasons why I say don't file it yourself. There's an enormous amount of bureaucracy in IP, and so if you file it yourself, you're just sure to get tripped up on this stuff. So having a firm file it for you is usually about $700 on top of maybe about $3,000 for the work of the patent attorney.
Right. Can you give us a few tips in terms of what we should keep in mind around trademarks and patents and copyright and that type of thing?
Trademarks, you want to be careful that you don't adopt somebody else's trademark. That's a pretty kind of a no-brainer, you'd think, but a lot of people don't bother checking. I mean, it's not something that you need to hire a lawyer to check for you. Okay, do a Google search, I don't know, to see if somebody else is out there using the trademark. The other thing you can do is the Office of Harmonization in the EU has trademark information. You can do a trademark search through that website for free. The person can just put the trademark in. Try to think of different ways to spell it, that kind of thing. You know, be a little clever about maybe the first part of the word. Maybe just use the first part of the word rather than the whole word. That kind of thing, so you get more hits. But the Office of Harmonization in the EU has a fantastic search engine that searches probably about, I don't know, maybe 20 different jurisdictions to see, including Japan and China and Canada, all these places. So you could pretty much get a good idea if there's anybody out there. And then you also have to figure out what class you're in. That's pretty easy if you go to IP Australia's website. Just type in goods and services, and there's, I think, about 38 or 40 classes, and then you just look through them. Usually in the software business, it's class 9. It could be if the telecommunications might be in class 38. But you want to look for similar marks out there in those classes. So, or if you just want to, you know, quick tour through that sort of stuff, call me up. So that's what I would do for trademarks, but I would not just start using a trademark. I would check to see, because what you end up doing is investing in your trademark. And if you invest in your trademark and then somebody comes along and says, hey, wait a minute, no, you can't use it, it's my mark, you're in the same goods as I am, and then you've got to change your mark, and all of a sudden your customers don't know who you are, and you got to start all over again. So it's really worth it before you embark on using a mark to check to see if there's anybody else out there using that mark. Don't get too married to your mark either. That's the other thing. You know, think of other options if that happens.
What do you think we should know about or keep in mind about patents?
Well, the first thing I did mention about don't disclose your invention, otherwise you lose your patent rights. So you just might as well forget it after that. But, you know, patent portfolios are absolutely the most impressive things as far as investors go, community goes, and your potential to actually reap the benefits of patents. You have one patent, that's not doing anything. One patent will buy you a cup of coffee. There have been, if anybody's watching the news about this, obviously Google bought Motorola's patent portfolio for $12 billion. It turned out that when they paid Motorola for that patent portfolio, there were 17,000 patents, of course. I used to work for Motorola, so I know this quite intimately. There were 17,000 patents. They got $500,000 apiece for each one. So a patent portfolio is a lot like it's priced a lot like gemstones. The larger the gemstone, the more you pay per carat. The larger the portfolio, the more valuable each individual patent is. So if you're going to build a patent portfolio, you've got the right ideas. Patent portfolios are absolutely the only way to go when it goes to patents at all. And once you learn what a patentable invention is, because a patentable invention is not what you think an invention is. I mean, we think of an invention as the wheel, or what do we think of an invention? Is this a microprocessor? That's an invention. No, not a that's not what we mean by a patentable invention. A patentable invention is just absolutely buried in minutia. You know, it's a tiny little thing that's different from the prior art. You'd never think in a million years that would be an invention, but it is. And so you have to learn what a patentable invention means, and once you figure that out, you can figure out very quickly how, you know, sorts out picture a portfolio of inventions. And a portfolio is absolutely the most valuable thing you can do when you're looking at patents. There's a lot of data out there about these big transfers of portfolios. I mentioned this Motorola and Google, but there have been enormous numbers of portfolio movements between companies. Microsoft bought up Nokia, and there were enormous numbers of patents that moved across that way. There's companies that, I think I mentioned BlackBerry. Did I already mention BlackBerry? Yeah, I mean, they're building their portfolio up so that they can sell themselves down the road for a higher price. So patent portfolios, that is the most important thing in building, having to do with patents at all. And like I said, the trick really with that is to figure out what we mean by a patentable invention. And I have to say that I worked at IP Australia for a year as a patent examiner before I got my law credentials in Australia. And it was an eye-opener, a big eye-opener, as far as what you could actually get a patent on. I mean, I have to say, after 20 years of practicing in this business, going and working on the other side really taught me it doesn't take much to get a patent. It takes very little.
Well, we've spoken a bit about software companies, but we see a lot of sort of service type companies, professional services. Now, is there a way for them to protect their methodologies or their management processes or those kind of things that make them special in that
The things that do make them special that they've actually developed, yes, because there's business method patents. So, I mean, there's a whole category of business method patents. I don't think that the IP offices like them too much because they're pretty hard to search. It's a hard thing to search. But that means if you can't find anything out there on it, you'll get the patent. Whether or not it's a valid patent is another question, but you know, you won't worry about that little detail at the moment. So, yeah, if you've got a business method that nobody's thought of, and it's not just some pure algorithm sitting in some computer program somewhere, where there's real input and there's real output, yes, there's certainly, you can write a method claim. In patents, you write device claims, you write component claims, you write methods claims, you actually write result claims, so that something that you are, do you understand what I mean by claim? The claim is the very last page of your patent. There are numbered paragraphs at the very end, and those are called the claims. And they define the metes and the bounds of the patented intellectual property. So a lot like for real estate, we'll have the boundaries of the land that have been surveyed or whatever, you know. So from here to here to here to here, that's what the claims do. So you will write a claim, an independent claim that might have elements A, B, C, and D, and then you might have a dependent claim from the independent claim that might add another element, E, and so on, you know, F, G, whatever. So your independent claim only has, say, maybe 4 elements, 3 elements. The fewer elements, the better, by the way. So the way that you claim something, you might claim a result, like, I don't know what kind of result you would claim in a business. How to generate a list of prospects. And then you might have a method where this is where I get my data, you know, specifically defined where I get my data. And then I do step B, which is I perform this number crunching thing. And then step C might be out pops this other set of data from the first set of data. And then I perform maybe another set of number crunching things on that. And then I have my output. And that's how I create this list of prospective clients. Perfectly patentable sort of thing.
Okay, so just to get to the sort of an interesting bit in terms of what happens if somebody infringes on a copyright or a patent or something that you have, what's the next step? What do you do when that happens?
You go see your patent attorney. If your patent attorney will actually do an analysis before any kinds of letters are sent, because there are laws about sending out letters that haven't been substantiated, especially in Australia, not in the United States though. that's why the United States, by the way, is the best place to patent. Australia is not the greatest place to patent. The best place and the most important place to patent is in the United States. So, but either place, you would most likely, it's iffy whether or not in the United States some patent attorneys bother with this part, but in Australia you must analyze whether or not the claims of the patent that you hold are actually being done by the potential infringer. And once it's perfectly clear, then you might send kind of a little nice letter about, hey, by the way, we think that there's possibility, so you're not threatening them with a lawsuit, and then you just try to work out with them that yes, we are, no, we're not, and then it might blow up into litigation, but that's not what you want, because that's expensive. And the losing party pays here for the winning party's fees. So if you lose, you're going to pay not only your lawyer, but their lawyer too. That's not true in the United States. Each party pays their own fees. So that's what you would do, and the same thing would be true with copyrights. Copyrights, you probably would have situation not in a software situation. I mean, it's so easy to write a different set of code to do the same exact thing. You might have that with media, certainly, where the rights haven't been assigned and then somebody goes out and uses an image or a recording of some kind, and then without explicit rights to do so, then you would probably have the same set of circumstances. You're just looking to obtain license fees mostly.
Great. And I know, Paula, that you have done a number of other interviews and have some educational material on that. If somebody wanted to see a YouTube video or other stuff that you've talked about, where do they go about finding more about your work?
Oh, I did in 1994. I did a video, only because I kept running into the same problem over and over again, which is that disclosure issue, in trying to make people understand that they just can't lose their rights and then expect to go and get a patent application written because it's invalid. And they would get mad at the messenger all the time, which would be me, and so I just decided to make a video about it. But there is the original patent troll on YouTube. If you type that into YouTube, you will see a video that I did, which lays out the exact same information that I just told you about disclosure and some other things that are kind of cute. I'm giving a CLE presentation for the New South Wales Law Society in March, where I talk about how to build a patent portfolio. So that would be useful for anybody to come in. Non-members can come in and hear that as well. I just gave a talk down at Engineering Australia, but I'm open to coming in and if a group of people want to get together and just learn what I'm talking about how to write their own patent application so that they can get the value out of their patent attorney, I certainly am in the process of putting together seminars like that, because I think that's what people need in Australia, given the lack of patenting in Australia and the barrier to this whole intellectual property procurement that I feel that the profession has created. So in order to allow people to access the IP system, if they want to get in touch with me and find out when I'm offering a seminar on how to write their own, I'd be happy to include them in my list.
Paula Chavez, thanks so much for your time today and a very, very interesting talk.
Thanks.